topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good morning. Welcome to another Ask the Expert show where we bring you the finest, the creme de la creme in the areas of legal, health, financial, and home improvement. Our show has been running nearly 10 years now. Our expert today has been with us now for several years. I am so glad they are a part of our TV, podcast, and radio now. Sometimes some people might say it may be a little bit of a sad subject, but what we're doing is we're going to educate you, and we're going to educate you with one of the finest law firms in the state of Florida, Holland Law Group. And we've got attorney Christina Gonzalez with us today. Good morning, Christina.
Good morning, Steve. How are you today?
You're so bright. This is early in the morning. You're bright and you're ready to go. And
sure am.
That's going to make for such a great show this morning.
Awesome. I'm ready for it.
Okay. So first of all, tell us about the firm.
Okay. So Holland Law Group, it is mostly a consumer debt collection defense bankruptcy law firm. Our main office is focused out of Bradenton, but we have offices all over the state. We help Floridians all across the state, every single county in the state. We offer services in consumer debt collection. So that means if someone gets sued by a credit card company, a loan company, something like that, we can defend those lawsuits for those Floridians. We also have an exceptional bankruptcy department. So we do file bankruptcy cases for those who need it. We also handle creditor harassment cases for creditors that aren't being very nice. And we also have foreclosure and loan modification departments. So we help Floridians all across the state in anything that has to do with debt.
Christina, how different are things now, say, compared to 2 years ago? Are there more people filing for foreclosure? Are people's debt mounting up more than ever? What's really going on out there?
Right. So during COVID, as we can all agree, things were a little weird. A lot of the courts kind of slowed down. I know that banks and foreclosures, there was actually a moratorium with evictions, foreclosures, the whole nine. So things really came to a halt. And that went the same for filings of credit card or loan cases. It was the same for bankruptcy. So bankruptcy over the last year or so has actually been at an all-time low. The filings have been very low. The moratorium on foreclosures and stuff have lifted. So we're seeing those foreclosures get ramped up. We anticipate because of that, there's going to be more bankruptcy filings, unfortunately. And we have seen an uptick in credit card case filings. So there's definitely an upward trend going on.
Well, I know today's topics is very important right now. And again, I just want to say I'm so glad that we have the Holland Law Group as our teacher. That's because you were educating people out there. And you know what? Don't wait too long. I've had several friends of mine who have filed for bankruptcy. First of all, they were a little embarrassed, and you don't have to be embarrassed. No. And take hold of it now. Don't wait till it gets out of hand. Wouldn't you agree?
I agree 100%. I come across a lot of people who think that bankruptcy is a bad word. It isn't. It is a right that this country gives you. In some countries in this world, you can go to jail for owing debt. We live in a country where that is not the case. So it is a legal right that we have, and it shouldn't be something that anyone is ashamed of. It gives you a fresh start. It gives you a breath of fresh air. And I think that a deserving debtor should get that fresh start. Absolutely.
You know, it's funny. We've gotten 2 text messages already from viewers for today's show, and they both kind of asked the same question. Can they contact you through Zoom or the internet?
We do have our website, so you can go to our website, and if you go to hollandlaw.com, there's a form that you can fill out, and we will contact you right away. You'll be set up with a consultation with one of our attorneys. The consultation is free. Whether that be for debt defense, bankruptcy, whatever the case may be, we'll get you to the right attorney to assist you.
Beautiful. Okay. So let's get right into it. So if a person can no longer pay for their credit cards, now they've been sued, what do they do?
Okay, so usually a lot of people don't know when they've been sued. And I say, you're going to know when you've been sued because someone's going to come to your house, it's going to be a process server, and they're going to hand you some papers, right? And those papers are going to have the complaint, which is the lawsuit that has been filed. And that paperwork is also going to have either a deadline by which you need to respond to that lawsuit, or it's going to have a date that you need to show up in court. So a little thing that I want to say about this, that paperwork can be served on either the person who's being sued, or it can be served with any co-resident in the house. So anyone that lives with you ages 15 or older can be served with these papers. And I say that that's important because I come across a lot of people who are like, oh, my mom never told me, my brother never told me. So it's very important if you're in that kind of situation where you think a lawsuit may be coming down the pike, let people know, hey, this might be happening. So if anybody comes looking for me, make sure that you tell me and you give me the paperwork, because all that paperwork is going to have crucial information. And if you don't show up to that court hearing, if you don't file papers on time, you've essentially lost your case.
Wow. Now, do papers have to be served? I mean, is there times where someone maybe really didn't get the papers in the mail?
Yeah, yes. So it has happened where people were not served at the correct address. It's usually that situation though. Let's not get too carried away, but it's usually people are served at an old address, and whoever's living there now has no idea who John Doe is. So that person never gets notice of that lawsuit. The process server thinking they got good service, the lawsuit goes forward, and the defendant in essence loses the lawsuit at that point. But if you figure out down the road that you were sued and you did nothing about it, there's ways to undo that, and we can help people do that as well.
You know, I think it's really important for people to understand you cannot just throw these letters in the drawer and think they're going to go away.
Oh, no.
And I got to tell you, I think is important that people know, I would not try to handle this yourself. I'm going to tell you why. You could say the wrong thing to these people, and it could be used against you.
Absolutely. And it's the same for debt. So that kind of sounds like something criminal, right? Anything you can say can be used against you, but it's exactly the same for civil stuff. And for debt stuff, a lot of people go to court. They don't know any better. They recognize the debt. They admit the debt. And in essence, the moment you admit the debt, it's long gone. The judge is either going to send you to mediation. They're going to make you get into a payment plan. If you can't pay, they'll have you consent to a judgment, which is not good, but we'll talk more about that later. So in essence, things that you say can bind you to this debt. And that's why I say it over and over again. It's very important to at least consult with an attorney. Get the ammo you need so that when you go to court, you know exactly what you can or cannot say. So you don't lose your case just because you said something you weren't supposed to say.
So let's say that the lawsuit was served and it includes the court date for I guess what you would call a pretrial conference.
Right.
What happens at the pretrial conference?
Okay, so in cases that have a pretrial conference, that's basically like a powwow before a trial, right? So nothing crazy happens on that day. You show up, and that's just to make sure that you don't get defaulted, because the alternative is if you don't show up that day, you in essence lose your case by default, which is no good. So if you have a pretrial date, you've got to go. And what happens there is, in essence, it's a conference between you, the creditor that is suing you, and the judge. and you have a conversation. The first thing they're going to ask is if you admit the debt or not. And the moment you admit or you recognize that debt, they may send you off to mediation, or they may set you for a further hearing down the road. A lot of times people deny the debt, and if they do, they will set the case for trial. Please remember that if you decide to represent yourself, a judge may have a little bit of leniency, but you have to understand the law. You have to understand the rules of evidence. The judge expects you to know all of these things, which is why I think it's very important, if you're faced with this kind of situation, to at least have a consultation with an attorney, see if there's ways that an attorney can help you. Because an attorney, at the end of the day, this is what we do day in and day out, and we know how to navigate these kinds of situations. So in essence, don't go to court alone.
You know, I think we should share this with the viewers, that it is so important once you retain, say, Holland Law Group, you got to be totally honest with them.
Oh, yeah.
Because how can you don't, this is not the time to be embarrassed.
Agreed.
Okay. This is what you do all day long.
Agreed.
And people get in trouble. It happens.
Absolutely.
I mean, that's why there's bankruptcy out there. And some
Absolutely.
of the wealthiest people have had to file for bankruptcy. But it's the point I want to make is it is so important that you're totally honest with your attorney.
Yes, please. That is a personal request. Yes, please. Be honest with us. It makes our job easier. We can fight better for you. So yes, open book with us. You have to be. The thing is, as I always tell my clients, I can get you out of the truth. I can't get you out of a lie. So please be truthful with us.
That's right. You know, there's so many different areas of debt relief. Can we go over all the different areas that the firm handles?
Sure. So I think our most prominent department would be the situation where you get sued, which is what we were just discussing. So if a credit card company or even a debt buyer sues you, we can defend those lawsuits. So we do our very best to try to get resolutions of lawsuits on dismissals. If it's a case where we can't just get dismissed and walk away, we negotiate with those creditors to do some sort of payment plan, a settlement, to get the best resolution for our clients. So that's a portion of debt relief. If there's a client that is faced with insurmountable debt, so I'm talking about someone who has multiple lawsuits or has judgments, maybe they have foreclosures in their record, whatever the case may be, we also offer debt relief via bankruptcy. So a bankruptcy is a very powerful tool. It's not a bad word, like I said earlier. And depending on what chapter the client qualifies for, they can even sometimes wipe out all their debt with one bankruptcy and not have to pay anything at all, which I think is amazing that is even available to debtors in this country. So it's a wide array, but it goes from either defending a lawsuit, doing settlement negotiations, or looking toward the bankruptcy if that's the best option for our client.
What if the lawsuit, the paperwork doesn't have a pretrial conference date, but directs that a response be filed by a certain date? Okay,
so when you have that kind of situation, there's in essence a deadline to respond. So there's no court hearing, but you've got to file paperwork in court. If you don't, it's in essence the same as not showing up to that pretrial conference. So you lose the case, you'll be defaulted, and you're dead in the water. So if you're doing this on your own, which I don't recommend, but you're free to do, you have to either file an answer by the deadline, you've got to file a motion for extension of time by the deadline, you've got to file something to avoid losing that case. And similarly, if you're served with a lawsuit, it has an answer due date, try to get in touch with an attorney to do a consultation as soon as possible. The quicker we get in on a case, the more time we have to do what we got to do to protect you.
I'm sure you do. You get cases that they did not show up for the pre-trial conference. They didn't respond to the lawsuit. I'm sure you get cases like that they waited too long. Is there still something you can do?
Yes, sometimes there is. So sometimes it's just a matter of circumstances that was no fault as to the defendant. So a good example was what we discussed earlier. They were served at the wrong address. So if they were served at the wrong address, they never had notice. If you didn't have notice, how could you file a response or show up to a pretrial conference? So yes, the law gives us some tools to backtrack on that. Absolutely.
So let's talk about judgment now.
Oh boy.
First, I'll tell people what that means.
Okay. So a judgment, in essence, is a piece of paper that gets filed in the public record in the county where a lawsuit was filed that says you owe the creditor money. In its simplest form, that's what it is. So a judgment comes to life after you've been sued and you lose the lawsuit, in essence, whether that be because you couldn't pay and you consented to a judgment, or whether that be because you didn't show up to court or you didn't file an answer. So that's how a judgment comes to life. That judgment is filed in the public records. And in Florida, a judgment lives for 20 years. So it's a very powerful piece of paper that not only does it live for 20 years, but it continues to accumulate interest over those 20 years. So a judgment that may have started off to be a couple $1,000 can turn out to be a couple of tens of hundreds of bucks at the end of those 20 years.
So does the judgment drop off after 20 years?
So what happens is that it actually expires. So after the 20 years, the creditor loses its rights to execute. So let me dive into this a little bit more. A judgment opens up basically an arsenal of tools for the creditor that gives them the power to forcefully collect. So that means that they can garnish wages, they can garnish bank accounts, and they can do that for the entire 20-year period. Once that 20-year period extinguishes, the judgment in essence dies. So they do not have the ability to involuntarily collect anymore. Some aggressive creditors will renew the judgment. So before that 20-year mark, there are some aggressive creditors who will renew the judgment, get another judgment, and then they have a judgment that lives for another 20 years on top of that.
And what does that do to you if after 20 years it expires?
Yep.
Is it still on your credit?
So credit reporting is a little odd. It sometimes shows up on some credit reports. Sometimes judgments don't show up at all. So judgments is not more so towards credit reporting, but more towards the public record. So if you are buying a house, for instance, and they do a title search, they're going to look in the public records and they're going to see that there's a judgment against you. So we have that situation pop up a lot with our clients where they're trying to sell their home and a judgment pops up and that's clouding title, situations like that. So at the end of the 20-year period, when that judgment expires, it's not going to cause those issues anymore when you're trying to make financial moves.
Let me go over again with all the ways once a judgment is entered and shows that there's money owed. What can the creditor, how can they try to collect on that judgment?
Okay, so this is the arsenal that I had mentioned earlier. The two most common ways are wage garnishments and bank garnishments. So with a wage garnishment, what that means, the creditor files paperwork in the court that allows them, in essence, to take 25% of the debtor's paycheck, each and every paycheck, until the judgment is paid in full. That's one way. The other most common way is a bank garnishment. So a bank garnishment is a one-time hit. Creditor files paperwork in the court, they get an order that says that they're allowed to freeze bank accounts. Once those bank accounts are frozen, it's a one-time hit. Whatever was in there gets forwarded to the creditor and applied towards the judgment. The thing is, these creditors are smart. So what they do is they usually try to do garnishments either on payday, a Thursday or a Friday. Sometimes they wait until the end of the month when they know that people have a lot of money in the bank because they know they've got to pay their mortgage or their rent on the first of the month. So those are really the two most common ways. Another way that's not so common, but I'm seeing a little bit more often now, a judgment creditor can actually levy vehicles. So they can actually levy a free and clear vehicle in the name of the debtor and sell that at auction, use that money towards the judgment. And then another thing that a judgment does is it creates a lien against real property. So once that judgment is recorded in the county in which it was obtained, that lien becomes, the judgment becomes a lien against any real property owned by the debtor in that county. The good thing is a judgment lien will not attach to homestead property. So you can never be forced by a creditor to sell your homestead property. So that's the good thing and all that.
So the creditor can't sell, satisfy a debt. They cannot sell your house
Exactly.
if it's your homestead.
Exactly. Luckily, Florida has sweeping homestead protection laws, which is very good for us. But let's say you have a vacant lot that you own that isn't your homestead property and it's free and clear. Let's say that lot's worth $50,000. That creditor, as a result of that judgment, can actually levy and sell at auction that vacant lot and get the proceeds and apply it towards the judgment. So it's a very powerful piece of paper, that judgment.
We just got a text in from Orlando. Michael from Orlando wants to know, can they take my car even if I'm upside down on it?
Okay, so can they? Sure. They can attempt anything that they want, right? So can they try to levy the vehicle? Sure. But most of the times when there's already money owed on the car or you're upside down, the creditor is not going to waste their time doing it. And the reason is they have to pay the sheriff to go out there. They have to pay auction fees, and they would have to pay off that lien that's on that car. And you and I both know that cars at auction aren't going to rake in thousands and thousands of dollars, right?
Right.
So it's not worth their time to do that. I think there's more, can they? Yes, but I think there's more risk when you have free and clear cars titled in your name.
Okay, we just started. This is for our first TV show. We're really getting a lot of text. I want to know again about a judgment, and about taking your monies out of your salary.
Okay, so I can touch a little bit more about that. So that would be called a wage garnishment. So the way that works is the creditor gets a document signed off by a judge, and that document gets sent to the debtor's employer. The employer is directed to file a response to that writ of garnishment within 20 days. That response that's to be filed by the employer indicates how much the debtor gets paid and their deduction. Whatever's left after all the deductions, the creditor is entitled to 25% of that every single paycheck until the judgment is paid off. So that's a big hit. If someone gets paid every 2 weeks and they take home, I don't know, $2,000, the creditor is taking $500 every single paycheck. So it can become a daunting amount.
What should someone do if they're offered a settlement by a credit card company and they decide to pay off, I guess, with whatever kind of negotiated monies there are? What kind of proof should they make sure they get so it doesn't come back on them later on?
They need to get that settlement offer in writing. And depending who the creditor is, you need assurances that if you pay as you agreed under that settlement, they're going to update the credit report and that they will not be issuing you any kind of 1099-C, tax consequences, that kind of stuff. The creditor is going to offer things that works best for them. So that's why it's very important to talk to an attorney to make sure that whatever settlement agreement you're entering into protects you, not protects the creditor. Because at the end of the day, they care about themselves. They don't care about you. At the end of the day, they just want money from you, and they're not going to be putting language in a settlement agreement that looks out for your interests.
You know, we've gotten a couple text messages wanting to know if your firm handles businesses also, and which today we're kind of doing consumer today, but you do handle business also.
We could. It depends if it's in a bankruptcy situation. We can do business bankruptcies. If we do primarily consumer debt, but if it is a specific type of business debt, we'll be more than happy to do a consultation on it to see if it's something that we can assist with. Absolutely.
Are there any remedies available to a debtor once their wages or their bank accounts have been garnished?
Absolutely, yes. If you qualify for them. So if you have wages or bank accounts garnished, Florida law allows wages and funds in bank accounts to be exempt from garnishment. And that would be only if you qualify as what's called a head of household. Head of household is someone who's the primary wage earner in the home, so it makes more than 50% of the income to the home, and they have dependents. So if you're a head of household, you would qualify to have those wages protected, which means that they cannot garnish you. That's awesome. Similarly, if you get hit with a bank garnishment and in that bank account there's Social Security, disability, veterans income, anything like that, all of those funds would be protected. So if that would be the case, the garnishment would be dissolved, you would get your money back. That doesn't mean the creditor can't try again. So just because they hit you once, you qualified for an exemption, doesn't mean that they back off for the rest of the judgment. They can keep hitting you with these over and over again to make it as inconvenient for you as possible so that you eventually fold and say, okay, I'm going to pay you something so you can get off my back.
You know, I'm sure you also get clients that have multiple, I guess, cases against them. What do you do then? Is it the same as there's one?
It depends on the situation, right? So it depends on the financial condition of the debtor. So if it's multiple cases and they're old cases because everybody went through a rough time a couple of years ago, right? And now that person is in a better financial situation, we may be better to just attack each lawsuit as they come in, settle out those that we need to settle out, and we can avoid a bankruptcy filing, save that for a rainy day. But sometimes when it's out of control, there's multiple lawsuits, they've got judgments, we've got garnishments, we've got a whole bunch of stuff going on. It may be better to just go ahead and do a bankruptcy filing. The moment a bankruptcy is filed, there's something called the automatic stay. And it's a very, very powerful legal tool. What that does is it stays all collection actions by any creditor. So you get instant relief. Garnishments have to be dissolved. Lawsuits have to stop in their tracks. So it all depends. That's why we do a consultation. Our consultations are free, and we determine what is best for that individual. Some people can settle them out one by one, and for some, it may be better off to just do a bankruptcy.
Okay, Christine, you know the old saying, we save the best for last. Well, this is where we save the best for last. Why should I hire your firm?
Because we are the best at what we do. We pride ourselves in taking the time to have consultations with our clients, learning what is best for their individual situation. What works for one person may not work for the other. We've been doing this for a very, very long time. We've gone toe-to-toe with some of the biggest debt buyers in this state. And I am very happy to say that we get excellent results for our clients. We pride ourselves on customer service. We want our clients to feel that even though we help many people, they're our only client. That's how we want our clients to feel. We have amazing attorneys from consumer debt defense all the way into bankruptcy. People have been doing this for a very long time. They're experts in their field. So I'm going to tell you something. If I needed help, I would go to Holland Law Group. Eyes closed.
Absolutely. And I understand. I see why they have you on staff.
Thank you.
Excellent answers. I know today we've really educated a lot of people. The good news is Holland Law Group's going to be back with us again next month. So you can start sending your questions in. We've been flashing the phone number throughout the show if you're watching on TV, but if you're listening on radio, tell people what your phone number is.
Absolutely. So you can reach us at 941-744-5450. We will set you up with a free consultation depending on what the situation is. And if you're not sure what the situation is, we'll get you with the right person, and that attorney will tell you which way you got to go.
And let's tell everybody also that the website is hollandlaw.com. That's Holland, HOLLAND law.com. And again, we are so blessed to have you as our expert in bankruptcy. We'll see you again next month. Thank you so much,
great.
Christina.
Thank you, Steve. It was a pleasure to be here with you this morning.
You did great.
Thanks.
And we will be back with you again next week with more Ask the Experts. Some of the finest experts in the state of Florida are with us. We will see you again next week. God bless everybody.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.